Okay. Good evening. As you know, this is Del Steady Merced. Today is Thursday, March 3rd, 2016. This webinar is being recorded. In a few minutes, Dr. Perry Serkel will be leading this evening's presentation. He will be joined by two of your colleagues, Ellen Aberbach and Aaron Turetsky. Thank you, Ellen and Aaron, for joining us tonight. I will be moderating tonight's presentation. Before we get started with the program, I must review a few items. First, the training materials were provided directly to each of you via email. The email included an affirmation form, and as I said earlier, in both Word and PDF formats. At various times throughout the webinar, I will display various codes that you must write down on the affirmation form. And if you don't have the affirmation form right now, write the codes down on a piece of paper and I will get you the affirmation form after the presentation. But write down those codes. All you need to write down are the codes on a piece of paper, and then you can fill out the affirmation form afterwards. The codes will not be read out loud. I want to repeat myself. The codes will not be read out loud. The course code is now being displayed on your screen. The course code is now on your screen. And I'm going to make it a little bigger so that you could see it, or at least put it as part of the entire, take out the background out of it. The course code is on your screen. Please write this course code number on the affirmation form on a piece of paper and then put it onto the affirmation form later. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by the NYSED for continued certification as a hearing officer. Please keep in mind, as NYSED has advised you in a July 2015 memo, only hearing officers who participate in the entire session of the live webinar program would meet the requirement for participation in the update training and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you view the live program for the full 2 hours. Partial participation will not be accepted, and the telephone option is not a substitute for the requirement that you view the live program. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, March 11th, 2016. Again, that date, Friday, March 11th, 2016. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Second, all participants will be muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to hear your thoughts on the discussion as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there is a question dialog box with the wording "Type questions here." It too will accept comments, obviously. Dr. Serkel will pause to take questions or comments throughout the 2 hours as time permits. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to provide us with feedback. Please take the time to provide that feedback. Let's begin. I'm going to turn over the screen to Perry. It's going to take a few minutes, so just bear with us, and then he'll tell you what you should be able to see. You should be seeing on his screen. The course code is up there right now. 3, 2, 1. Gone. Okay, Perry.
Good evening, everyone. Tonight's webinar has a topic that sounds initially very technical, adjudicative, and one wonders about it in terms of special ed and what we're trying to do for students with disabilities. But as you'll see tonight, this is a complicated and evolving topic that has great practical significance for both hearing officers and the parties. My basic purpose today is to just forewarn you of some of the key issues, but please understand right now that all of this is not crystal clear. It is still developing in your jurisdiction, and I just want to give you early warning in light of a case that has emerged in a circuit that is not binding to you, the Third Circuit, but is already radiating out through practice of hearing officers and causing lots of questions. Some of the questions we have answers for, others I want to alert you to so that you start thinking about it. What you should be seeing on your screen right now is on the left-hand side a PowerPoint that hits the key points that I'll be discussing, and on the right-hand side, the more detailed handout that includes citations. And as we move into this, the first part that I want to get to is just simply an idea as to what we're doing today. I'm moving down to the second page on the right-hand side of the handout material. And you'll see that we're going to start with a factual scenario so you can see concretely how the practical effects of this for the parties and the hearing officer. But then we will go back into sort of the more broad abstraction of what is SOL, statute of limitations, specifically under the IDEA for filing for a hearing. There are separate statutes of limitations as it relates to going to the review officer level and then to court, but we're talking about it at your stage. You're going to find that once we get into it, there is something that some of us call a triggering date, or you'll see a new acronym, a COSHC, which I will be explaining to you, and exceptions to that triggering date, which will extend back to an earlier point when the parent needs to, it gives them more time for filing. There are some other issues, like what do you do with admission of evidence, and some of what we're going to ultimately come back to is the case scenario. We'll be applying it, and there are no absolutely right answers. What we want to understand is what are the key questions that will be addressed. At the bottom here is the citation or the name of the case that is causing questions throughout the country. I have it highlighted. It's Third Circuit. The case comes out of Pennsylvania. It is neighboring to you, but not binding on you. But as you have seen it in your practice in the past, various court decisions from other circuits, especially if they're at the appellate level and are officially published, and this is an officially published case, tend to not be binding but often persuasive on Second Circuit. The Second Circuit itself, lower courts, review officer, and hearing officers. Along with this case, GL versus Ligonier School Authority, which is not part of the materials, but I have the citations here for you to easily access it. But along with that case, the other one that I would warn you about that may be of relevance to you, but equally is not as clear-cut and binding, is in footnote 2, KH versus New York City Department of Education. Notice from the citation that it is not officially published, thus does not have as much legal authority from the judge's point of view, and it dates back now to more than a year ago. But as we move into this, you'll see that these are the facts, just the skeletal allegations in KH that I've borrowed for our purposes. For those of you that prefer the PowerPoint, we are now at this case scenario. And notice that this student, KH, was born back in 1989. By the time we have filing for the case, he's at the very end of his statutory coverage. He's at age 21. But dating back in time, you will see various issues in chronological order. I forewarn you, number one, don't get distracted right now, although certainly it's of substantive significance, but don't get distracted right now at the varying IQ scores that one can wonder about, ranging from 61 up through 84. Similarly, do not get distracted at this point for statute of limitations purposes by the fact that at times a grandmother has the role of parent, and at other times the biological parent, mom, has custody. But although those are of interesting dynamics, they're not key to the case, nor is the changing identification. In kindergarten, the team for the New York City Department of Education, the CSE, had identified this child as having a specific learning disability. In grade 2, the diagnosis or classification switched to emotional disturbance, in part due to significant behavioral as well as academic issues, and a new placement. In grade 4, again, a change in both classification and placement centered on intellectual disability. In grade 5, there was a reevaluation that included a psychiatric report because the child's behaviors had become so severe that there was a 2-week psychiatric hospitalization. We have diagnoses added in, now not IDEA classifications, but quite relevant to IDEA classifications, of ADHD and oppositional defiant disorder. As a result of that psychiatric hospitalization, in grade 6, the child is now in a day treatment placement at a psychiatric center, and we find from another evaluation that there is documented progress in behavior, but negligible progress academically. Grade 7, the student is back in the district in a middle school special educations class. And by the way, as you track through, you will find that either the grandmother who had custody or the mother has participated in these various CSE determinations. We then jump to grade 9 because we're just taking a quick snapshot as to what was going on here. What we see in grade 9 is a recommended new change in placement as the child or student moves into high school for a vocational placement based on his low academic achievement, specifically on standardized tests. Now remember, he's in grade 9. We have a first grade level in reading, a third grade level in math. We've got some obvious problems, this case, for both the student, the parents, and the district. Moving on so that we get to the point of when the main issue is, did the parent timely file? That's what the statute of limitations is in this case. So moving on, we go to grade 10. We see, based upon the recommendation for a more vocational orientation, a career development center, and we're losing the participation of this student in that we have ongoing attendance problems. A couple of years later, the attendance problems have become so bad that at age 19, the program discharges the student due to his continued truancy, and when they contacted the parent about the truancy, what they regarded as a lack of an effective response or cooperation. You may have your own issues that you can wonder about at this point as to this discharge and whether that's a change in placement, etc. But due to the bare facts, at least at this point, one thing is clear, and that is for the following 2 years, in 2009, 2010, excuse me, and well, this happened in 208. So in 208, 209, and then in 209, 210, while the student was ages 20 and 21, he had no IEP and he had no services from the district's point of view because they had discharged him, but nevertheless, from a neutral point of view, he had not aged out, he had not been graduated, and thus there was still rather clearly, or at least strongly arguably, a continuing FAPE obligation that was clearly not met for a 2-year period. At the end of the 209-210 school year, parent arranged for a private neuropsychological evaluation. And in addition to multiple diagnoses that you see listed there, most of them relating to DSM-4 type diagnoses. But in addition to all of that, we also have the clear-cut notion that this student's achievement is way behind and that his academic progress after all of these years has been nowhere near what one would have hoped. And 1 month later, a few weeks before the student reaches the statutory ceiling, the parent files for an impartial hearing. Now again, I'm sure dancing in your head are serious concerns about FAPE and what happened with this student. But right now you'll see that we have a threshold issue, because in immediate response to the parent's complaint, and I'm down here in italics, the district makes clear its threshold argument that the parent's case is untimely based upon the IDEA statute of limitations. That is, that the parent did not file on time when she filed in June 2010. And by the way, whether you regard it as the parent or the student, given the age of this student, let's not again get lost in that. Let's just assume that the plaintiff has filed and the district is contending that filing wasn't on time. As an alternative argument, the district argues that if you, the hearing officer, finds that the parent did file on time, then they want a ruling from you that the scope of evidence and their liability for any denial of FAPE is limited to the last 2 years. That is, if the parent filed in June 2010 based on what is generally understood as a 2-year statute of limitations, it would date back, if this is timely filed, it would date back 2 years to June 2008. This is what some of us call a look-back period. That is, looking at the date of filing with the understanding that under federal law and New York law, subject to what we're going to get into here, there's a general understanding of a 2-year period for filing. That if you look back from the date of filing, you get June 2008. And this practice of this look-back period is very common nationally among hearing officers. I can also cite for you, as I did in my article that was sent to you about GL, several courts that have sort of automatically used this, and I just came across a review officer decision that did the same. Now that, so you understand it, is the argument from the district's point of view. The parent, presumably in the pre-hearing, if there is a pre-hearing, or early on at the very first hearing session, and or just by filing papers back through an attorney, counter-argues that the triggering date was May 2010, but that the district is liable for the entire educational career of this student, that is back to 1994. If you do the math, then it amounts to approximately 16 or 17 years that the parents want in this case and seek relief since there had been no unilateral placement, compensatory educational services, which in a previous webinar we had explained is a generally accepted remedy, but that there is a little nuance here about gross violations, whether New York requires, or the Second Circuit requires, a gross denial of FAPE. One could clearly see that there no IEP services for 2 years is gross. And the better view, although not clearly settled, is that this gross notion only applies beyond 21. This student applied before 21, so the parent's argument is 16 years of comp ed. On what basis? Well, first, the parents point out that if you use that 2-year period, there are 2 explicit exceptions, which we will examine momentarily, and that the parents argue that they are covered under one and or the other of the exceptions, which would extend the period back. Alternatively, if you conclude that the explicit exceptions do not apply in this case, they argue that there are implicit exceptions recognized in other areas of law, such as equitable tolling, since we're talking about an equitable remedy, which either includes or separately has the notion of minority tolling, here that the child was a minor and therefore the clock should not run until KH became 21, or the notion that we often see in areas like labor law, that there's been a continuing violation ever since kindergarten, and once you plug into that continuing violation by a timely filing, it goes all the way back to kindergarten when the continuing violation is started. And a third argument, if you find that neither of the explicit exceptions apply, and that for one reason or another the implicit exceptions do not apply, then the argument, which you'll see in a moment, which is like the continuing violation but separable from it, is if I filed on time, the underlying violation is this continuing denial of FAPE. The action dates back to 1994. That's when they first started denying FAPE to my child. You think that you would be done, but then the parent also picks up from some federal court cases, primarily from Pennsylvania, predating the GL versus Ligonier, and also including the federal district court case that was under review by the Second Circuit, of a notion that if I file within 2 years, I can additionally go back in terms of liability an additional 2-year period, and this maximum of 4 years is often called the 2+2 period. Now, at this point, you very well may have your head spinning. It does seem rather dizzying, and what we're going to move to now is trying to put in more clear terms what is the language, what are those exceptions, what is this 2+2 period, what are the other interpretations that are available to you as we develop a more settled and sensible state of the law in New York and in the Second Circuit, because it all starts with you. In getting there, and now we're moving back into the general notion as to what statute of limitations is all about, the first relevant part here becomes, what is statute of limitations? And you see a definition that I've listed here for you that comes right out of American law reports, a basic accepted treatise, and it makes me at least think of the recent clergy abuse cases, the Bill Cosby controversy, and various other major issues having to do with timely filing. What would be the purpose of letting Bill Cosby, a clergy, or in our context, a district, in effect, off the hook? Well, as a policy matter, balancing the interests on both sides, the two primary legs on which the statute of limitations generally rely are staleness and stability. That is, at some point, evidence, like try to find KH's kindergarten teacher and records and come up with reliable, valid evidence so we can make a determination now. It is often a challenge, and so this notion of avoiding staleness, sort of throwing out the bread after it becomes hard and moldy, is one rationale. And the other is this notion of repose or stability. At a certain point in time, whether it's an individual or an institution, we have to let bygones be bygones and be able to, whether it's for insurance planning or just mental health, be able to move on and focus on the future. And so at some reasonable point, based upon staleness and stability, it becomes just too late, much like Deus Steady's notion that you've got to get the affirmation to him by March 11th. As you digest those two rationales and whether or not and to what extent they apply to KH and his family in this school district, let me point out two sort of legalistic issues that may become, before I get there, by the way, some of you say, let me look at the footnote for a minute, footnote 6. Some of you say, well, that's from the legal treatises in very general. How about the IDEA? Well, I've quoted for you here from one of the IDEA statute of limitations cases having to do with timely filing for a hearing coming out of Michigan. And I just want to sort of apply that notion to this context, at least in the words of this judge. The 2-year period, and we'll see this 2-year period I talked about, under the amended IDEA, because this all goes back to the 2004 IDEA, which became effective July 1, 2005, that permits plaintiffs to exercise their rights within a reasonable period of time, protecting potential defendants from a protracted fear of litigation. That's a notion here of both stability and staleness, and promotes judicial efficiency by preventing courts from having to litigate stale claims. I'm sorry I jumped into that, but I just wanted to make sure that you followed that these rationales have been recognized in their application under the IDEA. Now I go to the two points that may or may not, depending upon your particular cases, come up or not come up. One is the notion of a burden of persuasion. Some of the issues we're talking about, the evidence can be relatively close, and thus we may be applying the burden of persuasion in determining what the triggering date, whether the exceptions apply. And it is generally recognized that the burden of persuasion in a close case is on the district. Why on the district? Because it is generally regarded as an affirmative defense, meaning, hey, district, as in the KH case, speak up in timely fashion. If you don't, then arguably you have waived that defense. And you will note, by the way, that in footnote 9, I have cited for you a published federal district court case, which in itself cites the Second Circuit case. The Second Circuit case, if you look at it, even though the date is 2008, is actually about the pre-IDEA statute of limitations, but the analogy at least was brought across by the MG case, that is, this notion of it being an affirmative defense. So in some jurisdictions it's not as clear-cut, but it seems to me that that's one of the fairly settled points that we can make, subject to other authority and arguments that some of you may face in your cases. And this notion here of waiver, if you look at footnote 10, I've cited an unpublished case at page 5 that seems to suggest this notion of waiver. As well as I put down for you a Pennsylvania. Now, SEA in this case would be a hearing officer or a review officer. In this case, it's a hearing officer case. That this hearing officer says that he would apply waiver at the hearing level, his reasoning being he found no authority on point in Pennsylvania, but in the absence of guidance, the hearing officer conclude the affirmative defense must be raised sometime before the conclusion of the evidentiary hearing. This notion of waiver, then, is not as clearly settled as the affirmative defense, and I ask you to examine these cases to be able to decide it or not. But again, these are fairly technical, nuanced issues. Let us move into the heart of the matter. Here is the actual language in IDEA 2004. And it was, as GL points out, and most agree, inartful language, inartful drafting that became binding because Congress adopted it and the President signed off. In one part of the IDEA, and this language is restated exactly without elaboration in the regulations, and New York has mirrored this language. It says that the parent or agency, but in our case, in most cases, it's the parent, must file that hearing within 2 years. That's that 2-year period. But rather than being 2 years looking back from the date of filing, it's 2 years forward from the date that the parent, I'm skipping the agency for a minute to make it simpler, that the date that the parent knew or should have known about the alleged action that formed the basis of their complaint. The rest of the language just allows the state, like some of the cases cited in my article to you were from Texas. Texas changed the statute of limitations for filing for a hearing from 2 years to 1 year. That allows that Texas law to be effective. But it is simpler for us in New York. We mirror the language. So the relevant point is, parent, if you're the one that's filing, you must file within 2 years of what I've called the triggering date, what the courts have called the Kosh date, the date that the parent knew, that's the K, or should have known. If you take the letters that begin those words, you get K-O-S-H-K. That's the Kosh date. You've got 2 years to file when you knew about the, in effect, violation, denial of faith. Now, if that's all it said, it would make things fairly simple. But in another part of the IDEA, still talking about due process hearings, now talking about the complaint that the parent files, it says that the complaint, if it's the parent that's filing it, sets forth an alleged violation. Now, to me, before we go on, the alleged violation, I believe, is synonymous with the alleged action that forms the basis. The alleged violation that occurred not more than, we see 2 years again, but then it's from the date of the Kosh. Now, I'll stop for a minute and define what some have interpreted these two provisions to mean. A 2 plus 2. If you pick the Kosh date as the date that the parent knew, let's assume, just for the sake of argument, that the parent knew in June of 2008 or should have known about KH's loss of faith, then the parent must file by June of 2010. In other words, you take the Kosh and you move forward up to 2 years. This language seems to suggest, yes, take the Kosh, but now instead of moving forward from the Kosh, you can go back 2 years to the date of the violation. Thus, those that interpret the language that way essentially say, if the parent files within 2 years of the Kosh date, then the evidence and the liability extend back an additional 2 years if the parent proves that the alleged violation started 2 years before the Kosh date. That's the 2 plus 2 that some federal district courts in Pennsylvania, which is the sort of leading jurisdiction for statute of limitations case law, that have then radiated elsewhere. And it was the GL court, trial level, district court level, that adopted the 2 plus 2 based upon 2 previous federal district court cases in New York, that then went up to the Third Circuit, and we'll see, just to give you a preview, Third Circuit does not agree. Now, in GL, remember, the Third Circuit. In GL, the district wanted 2 years. The parent argued 2 plus 2. And you'll read GL for yourself when you get one of these cases, and I predict that some of you will, and you will find that that's the vague part of GL. It's 2 plus, some say, infinity. Others say 2 plus the action, wherever the action started. It is, in effect, better than the parent was arguing, because it's not 2, and it's not 2 plus 2. It's 2 plus what can well be, depending upon the facts of the case, well more than 2, and potentially in KH's case, going back all the way to the 16-year kindergarten point. But I'm saying potentially, and a lot will depend upon you, the arguments of the parties, if they raise this issue, and some will, and the cogency of your interpretation, not mine, not the Third Circuit's, and not necessarily KH's, that in the future we can come back and say, this is what it is, at least in New York. Right now, we're not sure. Moving forward.
Perry?
On this. Yes?
I want to take the screen and put up a code.
Understand. Go ahead.
Okay, so I'm going to do that. Bear with me, folks. Okay. You seeing my screen, Perry?
Yes.
Okay. The code number 2 is on the screen, folks. Code number 2 is on the screen. While I have that up there, I just want to highlight. Some of you said that although you received the other materials, you didn't seem to have the affirmation on that same email. I have uploaded the affirmation document to the control panel that popped up on your screen when you signed in to GoToWebinar. You can find that document. It's a Word document. It is in the section called Handouts. It's in between audio and questions. There's multiple sections on your control panel, and the section Handouts is in between audio and questions. There you will see a document labeled affirmation.doc. If you press on that document, it will download the affirmation onto your computer right now as we speak. So code number 2 is up there. Please write code number 2 down on your affirmation. Code number 2 is on the screen. Please, 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 please write code number 2 down on your affirmation. Well, I leave that up there. I have a comment or a question from one of the hearing officers. Perry, it says, I see 2 plus 2. How is it again that you get to infinity?
Okay. The best answer is, you can get to infinity when we talk about GL versus Ligonier, because one interpretation of GL versus Ligonier, maybe infinity obviously overstates it because there's always a finite point in schooling, but GL versus Ligonier seem to suggest that in a case like KH, the facts we looked at, that if the parent timely filed within 2 years of the Kosh date, then you go back to the original denial of FAPE, which potentially, depending upon the legal conclusions based on the facts in the case, potentially could go back to kindergarten. Now, there is an added little nuance having to do with the qualitative calculation of Comp Ed, but leaving that out, the basic notion is you can get back to what I maybe miscalled infinity, but you can rubber band like go way, way back, because now we're back to, if you can give me back the screen, Dave Steady.
I will. Code number
Thank
2
you.
is gonna leave the screen, folks. It's yours.
Thank you. If I go back just one slide for a minute, again, the notion of how does one get from 2 to either 2 plus 2 or 2 to what I'll recall instead of maybe infinity, an elastic band. What I would do is look back at the language. And it seems to me that what the Third Circuit arguably did was it looks at the Kosh date, and if there is timely filing within 2 years, then it says look back to where the action that formed the basis of the complaint, and at least in the KH facts that I gave you, the parent may well argue it dates back to kindergarten. I promise you it will become clearer, although never crystal clear, but it will become clearer, this sort of rubber band, as we get into it. And to get into it, and by the way, at the end of this slide, I'm going to stop and see whether either Ellen or Aaron wants to give us some initial representative impressions, although they certainly don't have to. But just so we see that we're all on the same page and it's not crystal clear. But the first point I want to make is the notion of Koshk. If the parties raise this issue in timely fashion, then it seems to me the very first issue that you're going to need facts on for you to make fact-finding and by the end of this hearing, and that you're going to come up with legal conclusions, is to specifically determine what is the date that the parent, if the parent was the filing party, knew or should have known of the alleged violation. Once you have that date, let me use the example again of KH. Let's say for whatever reason you say the parent first knew when she took custody in 4th grade, and that goes back to, like, I don't remember the year, but like 205. She had 2 years to file. She didn't file until 210. Case dismissed. Out of luck, no timely filing. So that's what I mean by forward counting. Now, if what I say here is compare this notion of a look-back period. Now, here I'm going to talk out of one side of my mouth. I'm no longer being the neutral, trying to understand. I'm giving you a very pragmatic view from one person's point of view that you can easily disagree with and do what you think is fit. But if I'm the hearing officer and the district doesn't, and the parent files, and the district doesn't raise an affirmative defense in timely fashion, then what I'm going to tend to do would be to use the look-back period, even though it's technically incorrect. Why? Because 1, it's the prevailing practice. 2, we get on with our case. Everyone can presumably agree parent filed on a certain date. Therefore, I'm going to go back a maximum of 2 years for the denial of FAPE, and I'm not going to go back more than 2 years for evidence, except for quick evidence for broad background. Otherwise, we're going to move forward. Why am I doing this again? Because I don't want to get caught in this quagmire. And often by doing this, I can get the parties to either acquiesce or actually stipulate, because for many of the parties, this notion of look back resolves it. And some of you say, well, how do you do that? Well, if we can all agree that the Kosh date just happened to be 2 years ago, then the look back period is correct, because when you look back 2 years, it is the same thing as looking forward 2 years if we engage in this legal fiction, what is often accepted that that is the Kosh date, and then it avoids all of this complication, and we can get on with our 45-day period, limit transaction costs, and folks can get back to helping to educate students with the limited resources. But that's just my little pragmatic aside, taking off that hat and going back to the pure neutral and theoretical rather than pragmatic. You've got to figure out the Kosh date, no matter what circuit, Second Circuit or Third Circuit, it's in the statute. And if the parties have raised this issue, then you face this problem. But there is a second, in effect, Kosh date, not really Kosh, but a second date. And that is, what is the date that the alleged action that forms the basis of the complaint? And if you're wondering where I'm getting this, go back again a slide and you will see that that language is right in both of the twin provisions of the IDEA. There has been some case law as to what do we mean by the alleged action, and it gets rather nuanced, but it brings up a word that can be problematic because it is used and misused in many different cases under Section 1983 and IDEA without consistent clarity. The notion of when did the claim accrue, and this language is particularly applicable, especially in the Third Circuit, since it's the heart of compensatory education land. The notion which came up in GL about compensatory ed, when did the claim for compensatory education accrue? I'm not putting the language down as being irrelevant. It is relevant. The problem is that it is not entirely consistent or clear. Nevertheless, you'll see this language when it comes up for not only comp ed, but mixed together the alleged action. And in other cases, like in footnote 15, when did the parent have the necessary information? And it gets nuanced. But to make it simpler, if it's not the KH case, if it's what most of you, especially in New York City, encounter, tuition reimbursement cases, then frankly you've ducked bullets, although there's still some calibrated edges to it. But the simplistic notion is, in a unilateral placement case, tuition reimbursement, there seems to be general agreement by both the courts and essentially by the parties that when the parent placed their child, it's because they knew or had reason to know of a denial of faith, reinforced by the language in the tuition reimbursement provision, which talks about providing timely notice to the district based upon the date of when the child was first enrolled or placed. Thus, in a tuition reimbursement case, it is relatively clear that the parent has essentially 2 years from the date of placement to the date of filing. And if they wait longer, they're essentially too late. If they're within that period, they're okay. Now, of course, everything can be nuanced, and there is, as I point out in my article, some little nuanced notions of what is the date in a unilateral placement of enrollment. Is it the date of deposit? It is the date of notice? Is it the date that the kid physically? But without getting into the nuances, at least it's much simpler than a comp ed case. KH, unfortunately, and increasingly you're going to find more comp ed cases. They're the ones that get super complicated. But tuition reimbursement cases are much easier because the Kosh becomes the date of alleged action. They sort of merge.
Hey, Perry.
In a moment, I'm going to the exceptions, but I promised to stop. And before Dave Steady speaks, I just want to see, because they've been very courteous and kind to me, but whether Ellen Aberbach or Aaron Turitsky has any question or comment at this point. They're going to have to, mute
They're on.
mic. Ellen or Aaron?
Go first.
Okay, Aaron.
General issues come to mind. One is, if I, as a hearing officer, decide we're going back to '94, how many hearing dates is that going to take to get that evidence in? The second thing that comes up, if we're going back to '94, are we talking a greater issue here than just fate? Was there not perhaps some sort of, what I'll term, for negligence on the part of the school district that's beyond, an impartial hearing officer hearing? I don't know. And then, how would you ever give 20 years of comp ed?
Good. Aaron?
Harry, I have two comments on what you've covered thus far. First of all, I like the 2+2 interpretation based on the language of page 6 of the handout, which is the actual language from the IDEA. Now, I'm very suspicious that this was not drafted deliberately, and there may have been some error or sloppiness in draftsmanship, but to me, reading these two provisions, 2+2 is a straight-out reading of them. That's my first observation. The second observation I have is that I have never, leaving out tuition reimbursement cases, which you've said are the exception, I have never, ever, within memory, heard anyone talking about the Koch date at a hearing. It's always 2 years look back. And just, I have vague memories that the district could have argued in any number of cases, well, wait a minute, you have this independent evaluation, and it says this, and you're faulting us for not having done anything about it or known about it, but look, your independent evaluation even references an evaluation we did of your child in kindergarten that talks about the same thing. So you should have known about this in kindergarten, not in 11th grade. I have never heard a district make that argument.
Now, Dave Steady, let me just quickly respond to these very insightful and pertinent reactions. First, let me reinforce. I agree wholeheartedly with Ellen that within the context of the 45 days and all of this emphasis on getting things moving, you go back to 1994, one of the vast implications is the number of sessions, the amount of evidence, along with staleness, and then if you do conclude that there's been a denial of faith, I don't want to be KH because you are going to be giving me 16 years or more of compensatory education. That's more than I really like, in that I'd like to see the Super Bowl, etc. But we have these very practical kinds of issues, and then when we move over to Aaron's point, the plain language of the IDEA would seem to partially solve these problems by saying, we're not going back to 1994. The most we're going back to for a filing in 210 would be 208. It would be 4 years. It's still going to be potentially a lot of evidence, a lot of sessions, a lot of comp ed, potentially, but at least it's not that notion of a rubber band-like infinity. Finally, if you are Aaron, and if the parties, now he pointed out, they haven't brought this up, and my view is if they haven't brought it up and they're happy with the look back, I'm not going to raise that issue sua sponte, not only because I'm making tricky matter for everybody, but there's some legal authority that hearing officers are without authority to raise an issue on their own and thus could be reversed on that basis alone. If, on the other hand, the parties at least raise it enough that you can address it, and if you, like Aaron, like the 2+2 based on the plain language, the tricky part will be, I think, to first distinguish that GL is not applicable and that you do not agree with the authority in GL. And when you read GL, you'll see that they dance around the plain language rule and somehow conclude, based upon legislative history, etc., that Congress intended both of these two provisions to mean a 2-year period. But then when they move on to Comp Ed from the Third Circuit, you get this 2+ rubber band, if you will. But what I'm saying is, it would seem to me to be cogent on appeal, you'd have to first show why GL is distinguishable, and thus you can import the lower court decision in GL and the two other cases, including, if you look at footnote 13, Jana K, because Jana K is a published decision from the Federal District Court, and you can agree and borrow their logic and I think come up with a defensible decision if you want 2+2, but you can't just sort of pull it out of the air. It seems to me to be defensible if you suspect appeal. You're going to have to deal with some legal authority to distinguish and then adopt this viewpoint to show that there's judicial authority for the 2+2 language. Now, Dave Steady, I think you were going to raise some questions that may have come in or comments.
Yeah, I have a number of comments and a couple of questions, some strong opinions too, which I think are worthy of sharing and you reacting to. The first is that I think Perry is being a bit disingenuous by saying that the Third Circuit opinion in GL can be interpreted to hold more than 2 years for the look back. It absolutely said that, though Perry may disagree. By the way, I was involved in the amicus brief that convinced the court on that point. The same hearing officer says when the action accrued is not the same as the statute of limitations. Do you want to react to that before I move on?
Yeah, I think maybe it shows that I'm not being as clear as I should. I'm not saying that GL talked about a look back. It seems to me that GL disagrees with the prevailing practice of look back. It goes and is relatively strict about a look forward from the Kosh date for 2 years. If that's clear, what I'm saying is GL can be read more than one way as to, once we have a timely filed case, how far back can you go? That's what I meant originally by infinity. Then I revised to rubber band. I agree that it is clearly more than 2. But what is the finite point more than 2? That's the part that I think can be interpreted more than one way, especially in New York, because GL imports the whole Third Circuit precedent of Comp Ed, which is not necessarily shared in the Second Circuit. Let's move on to whatever else you have because of time.
Yep. Another hearing officer states, Ligadier stands for a relatively simple and in some senses uncontroversial premise. The statute of limitation and remedy are separable and indeed unrelated. It concludes that you have 2 years from the Kosh date to file. Then you hear the allegation of liability, a denial of FAPE arising from the defective act or failure to act alleged in the complaint. Once there has been a determination of liability, you then proceed to the remedy, and by extension, any equitable reining in of the remedy. And the remedy is very like the remedy detailed for a Comp Ed claim in Reed. You try to get the kid to reach as swiftly as possible the point he or she would have reached had he received a FAPE since the very beginning of his education. So the scope of the complaint is not extended beyond the 2 years, but neither is the scope of the hearing officer's ability to define a remedy diminished by the statute of limitation.
And my reaction is that it sounds like a fellow professor. That is very clear that you separate out the notion of the filing period from the liability and the remedy. However, if we had time with my colleague or when we apply it to the facts, what I think is still left in question clearly from GL is what is the starting point in a case like KH of the liability, and then with this equitable reining in, what is the point we would start our calculation for the remedy in a case like KH. And there I think there's going to be major disagreement, and there has to be more clarity.
Two more, two quick ones. With respect to the COSH for tuition reimbursement, isn't the date that the CSE, the Committee on Special Education, made its recommendations the date the parents knew or should have known?
That's an argument, but I don't think, and there's only limited authority which I've cited for you, but it would seem to me that although one can argue that that in effect is the alleged action, but the parents' COSH, their knowledge of the action, it seems to me, is when the parent actually said, I don't agree with you, you've denied FAPE, and I'm putting my child elsewhere. But frankly, whether I'm right or you're right, at least those dates are much closer to each other and don't lead to the same kind of problem we have with Comp Ed as to liability and remedy. And the last one, Deo Steady?
And the last one, I believe, is a reaction to or a response to what Ellen was asking, but it has an interesting point that I think you would want to comment on. My current New York City case took 8 days. Parents want to go back to 2002. District argues statute of limitations. I'm going back to 2010 or 2011, which is 4 years, the student's high school years, using continuing violation, not the 2+2 GL.
Yeah, and I think that's a nice transition into where we need to go next, which has to do with the exceptions, including the one you just mentioned of continuing violations. But please pardon me, in getting there, I want to cover the ones that come just before that. We will get to continuing violations. More often, as the parties become more savvy on this, and it seems to be this notion of savviness results from two different sources. One, the practice of special ed law, especially in a highly litigious environment like New York. There's an evolution, a maturation that it gets more and more sophisticated legally as good advocates are trying to represent their clients effectively. But the second point is GL. Once the Third Circuit came down with this major case that has this rubber band-like quality, it has accelerated the process such that when Aaron says he doesn't recall anyone bringing up the COSH date, I'm sure there's lots of hearing officers who would agree wholeheartedly. But I predict that most of you will find these kinds of things coming up. And once you talk about COSH and GL, which says we're strict about this, then you get into the two explicit exceptions which are in the IDEA accompanying the language we had just looked at. The full language right from the statute is on your right-hand side. The shorthand version is misrepresentation. The other full language right from the statute, repeated in the regs, is information withholding. Those are the two explicit exceptions. And there have been various lower court cases from various jurisdictions around the country, including a little bit that I put in bold for you, for New York being basically a couple of unpublished cases. Most of the case law thus far has arisen in Pennsylvania and in Texas, with some scattered other jurisdictions. Because of time, I will just simply boil it down that if you look at the case law thus far, although it is not, and by the way, GL did not address this, and there are very few circuit court cases. The big one being the predecessor to GL, DK versus Abington School District, another published case from the Third Circuit preceding GL by 3 years, but the leading case that's been adopted in most jurisdictions, although again it's not binding on you. And to boil it down, if you look at DK and these other cases, they take, it seems to me, when you look at it impartially, a rather strict, not generous view of these exceptions. It takes the notion of misrepresentation. For example, many parents will testify credibly that all through all of these meetings, they got a lot of positive reinforcement. What a wonderful child, and how well he's doing, and how well I am as a parent. And now I find in the 12th grade, when my kid graduates, that he can't get a job. They have misrepresented the information. That's the parent's view. If you take the prevailing court view, it's sorry, parent, that's not what we mean. That's just sort of like the puffery of advertising and the spin of positive behavior modification, if you will. The proof has to be, and by the way, if the burden is on the district, as it is for the statute of limitations, the burden shifts to the parent, if the parent was the filing party, for the exception. You've got to show, number one, intent. It becomes like fraud or deceit, that they were using this puffery to fool you into not filing. And even if you show that intent, you have a second essential element, that intentional fooling of you is why you delayed filing, and not the fact that you're in a troublesome divorce with your husband, or poverty has taken its toll on you, etc., and that's why you didn't file. And thus you find very few successful cases when we actually, when the parent raises the issue of misrepresentation. Again, read the cases for yourself, come up with what you think is a judicious and judicial approach to misrepresentation, and I'm just giving you one reading of the case law that I've seen. Same happens for information withholding. Oh, you gave me the evaluation report, but I wanted some RTI data, and I wanted this, and I wanted that, and although I didn't ask for it, you should have given it to me. That may well be the sincere perception of the parent. When we see the information withholding cases led by, again, the DK case, footnote 22 and 23 and 24, in most courts, the court is, again, rather stingy and said, can you show not these other documents or piece of information? Did you get the required procedural safeguard notices? And even if you didn't, did the lack of them, is that why you didn't file? And if you can't show both on a preponderant basis, then you don't qualify. Now again, GL did not address either one, yet because of GL and its relative strictness on the 2-year period, what was called look back, but I would suggest is COSH looking forward. But because of the relative strictness of the 2 years, you may find more pressure for the 2 exceptions, which were not specifically addressed in GL. Now, as you digest it, before we leave this notion of exceptions, there are 3 other asserted exceptions that could be asserted, which are implicit. One is the general notion that, you know, a case like GL, I mean, just as a matter of equity, if they have been denying FAPE for this kid for a long period of time, you shouldn't let them get away with it. It's sort of like a reliance kind of, I was relying on them as an equitable point of view, you should extend the filing period. Or based upon the fact, as you'll see, like Ellen had mentioned, the possibility of sort of a separate tort claim Well, if you go to negligence, you'll find in most jurisdictions, or in several jurisdictions at least, the time for filing a negligence case, like in a car accident, doesn't count, the clock doesn't run against a child until they reach the age of adulthood, which itself becomes tricky in the disability area because of transfer of rights. But just digesting these. And the third one, which was the question again, is, can't you use this notion of continuing violations? That if they denied FAPE in 10th grade, and if it was just continuation of the same kind of, in effect, negligent behavior, then it goes all the way back. And in short, you will find that most courts in the post-IDEA cases, that is after 204, cases arising after 204, have reasoned that, yes, there are these three pre-existing doctrines, but Congress's intent by coming up with two explicit exceptions was to, in effect, reject these other exceptions. They no longer, or they do not apply. Now, again, you may find a way to establish them, but if you do, please write a very cogent opinion citing strong legal authority, because it is very probable that the appealing party, in this case the district, they know what they're doing, will be citing various cases that show that that logic doesn't hold. But again, most of these cases are from other jurisdictions. Now, when we look at KH and some of the other cases, we're going to find a way that arguably de facto might be continuing violations. But if you go that way and you cite KH, which we'll look at before we finish today, hopefully, at least the relevant language, again, like GL, to me, rubber band-like can be interpreted various ways. But one way is, in effect, to go back to like 94 without mentioning, because KH didn't mention continuing violations, but got to the same point through the language of accrual. Now, I'm going to stop again and see whether either Aaron or Ellen has any comments, or Dave Steady has, but I forewarn us that we've got 45 minutes left, and we want to make sure we get to applying the facts at the end, but we can at least efficiently take any that you might have.
All
So
right,
Dave
I will. I'm just putting up for everyone to see. I am showing you the code number 3. Please write down code number 3 on your affirmation form. Code number 3 is on the screen. Please write it down. There are a few comments and questions. I'll go through them quickly. I don't think that...
Before you do, can we give Ellen or
Sure.
Aaron a
Sure.
Either of you have anything that you think is for the good of the group you'd want to register at this point? You don't have to.
I just have a quick sort of an aside. I once had an administrative law professor say that there was no such thing as legislative intent.
Did you have the now deceased Justice as your law professor?
No, I did not.
I'm just saying that because there are various opinions from Justice Scalia which would seem to agree. Or at least legislative history, I should say. Thank you for your aside. Aaron, anything from you?
I have one, Perry. I just would like your opinion on this. Am I correct that the language specific misrepresentations by the local educational agency that it had resolved the problem forming the basis of the complaint allows for a whole host of other misrepresentations?
It's interesting. I've never thought of it that way. It would seem to me, again, if we look back at KH's case, what we're talking about, at least in this case, it's not a child find case, it's not an eligibility case, it's your usual denial of FAPE case. So I believe that the alleged actions and thus the misrepresentations, although they may come in various forms, would be about the denial of FAPE. And if you say it occurred in fourth grade, then what did they intentionally deceive you about in the fourth grade that caused you not to file within 2 years of the fourth grade?
But let me give a more concrete example of what I mean. I won't take too much time with it. Let's say a parent alleges that the kid was having all kinds of social problems relating to other kids, and the district told the parent and led the parent to believe that it was aware of those problems and resolve them and resolve them. Okay, that seems to come under this language. But what if the district just told the parent that the child gets along fabulously with other kids? That would seem to be an allowable, so to speak, misrepresentation.
Now, again, if the rest of you to join Aaron, because it's an insight that, frankly, I had missed, he brings us back to the plain language of the statute that I excerpted for you on page 8. And although I focused on the language of specific misrepresentations, he says, well, read on. There's a predicate that it had resolved the problem that formed the basis of the complaint, and gives us this issue of social, it could be bullying. Now, if bullying is the heart of the denial of FAPE, as it was in TK, then I think we'd all agree that that kind of alleged resolution would be relevant. But if a parent is talking, it seems to me, about social problems and or bullying that are not sort of the key kernel to the denial of FAPE, then it seems to me it's a distraction, and I'm not going to really try to bother about it because of the limited time. But again, because of our limited time here, I thank you, because it is a nuance I missed, and it may well come up in one of these cases, and one of you may come up with a much better answer than I had. Dave Steady, do you have any comments or questions before we go on?
I do. One comment is, I don't think the starting date can be anything but the date when the parents knew or should have known of a violation. It's the date when the credible evidence demonstrates that the parents were dissatisfied with a identification program or placement and had received their due process notice but failed to initiate a complaint.
And I think we can all agree with that, but the problem again is its application. If you look back at the facts of our case as just one quick but flagrant example, I'm not at all sure from what we see there, and of course there's going to be more evidence, when did this parent first become dissatisfied? If we use this language of dissatisfied with the program of their child. And by the way, we will also see some very artful preparation where, in effect, the parent will be testifying, I didn't become dissatisfied till I saw the evaluation report in 2010. All before then, I was a happy camper, and thus that's the COSH date. And yet the district will say, well, maybe you weren't dissatisfied, but you had reason to be dissatisfied earlier when we looked at all this other data and did the evaluation and the reevaluation and the change in placement, and thus you had reason to be dissatisfied earlier. Moving on, because that's as satisfactory or unsatisfactory.
Okay. Based on case law and or an evolving rule on the applicable statute of limitation, date of enrollment, notice of actual attendance in the non-public school. I think this was a combination of two questions. So I think the issue was with tuition reimbursement as to the trigger date, as so to speak.
And that's the one we covered a little bit before, and apparently is subject to more questions than I thought. But again, it's a relatively narrow range. It's either when the CSE proposed the placement, which is what one of the participants had suggested, maybe it is, that's an upper limit, or it's the date that the parent put a deposit down, or it's the date that the parent actually gave notice, if they gave timely notice, because they're telling you at that point that they're dissatisfied, or it's the date that the kid enrolled. Now, although that's a range of various dates, they're all presumably within something like a 4 or 5 month period, whereas we're dealing with a 16-year period in our case. So I think it's something to sort of concern ourselves with, but not as big an issue as these comp ed cases.
Okay, I have two quick ones here. Is the intent A, affirmative assertion of facts, no, not to be accurate or true, or B, affirmative bad motive for assertion of facts that are not accurate or true?
I'm not sure of the context of that question. Are we talking about one of the exceptions?
It goes back to one of the exceptions, the misrepresentation.
Yeah, frankly, at this point, I've given you as much as I think we ought to, because we can get lost in some of these nuances of the exceptions, and our purpose within our 2 hours is just to be able to sort of map out where are the dry spots, where are the sticky spots. That's one of the sticky spots, but a very nuanced one. There's several other spots along the way that are major swamps. So I'm going to push forward and not address that one.
Okay, and and I'm going to turn over the screen to you. Code number 3 is going to go, and then I'll ask you the question in the meantime while you're getting the screen. Code number 3, and by the way, as I was teased, it is spelled correctly. So code number 3 is up there. Perry, you're now going to have the screen, and I will ask you the last question. What constitutes an alleged action is harder to pinpoint. Is it really an action, or more likely district inaction or inertia and parents' failure to perceive a problem?
And that leads us very nicely, it seems to me, into page 10 on the material, or the slide that says duration and effect, because it's pointing out that we have this notion, if you look at my first bullet, if the parent did timely file within the period of 2 years of the Kosh date, then we get into this notion of the action, or as been pointed out, often the action or omission is, the commission is really an omission. It's a denial of faith. It's an inaction. And although Congress said the action that forms the basis of the complaint, I think you're right that it is an inaction, but either way, it's hard to figure out what that date is, and whether or not we have to figure that out is the GL question that I'm now addressing. So although it's not addressed in New York, the likely answer is that the period, the so-called look back, is a look forward. I think all of us can agree that, subject to the exceptions, once you found the Kosh date, then you look at when the parent filed, and if they didn't file within 2 years and there's no applicable exception, that's the end of the case. But if, on the other hand, it's not the end of the case, then we get into this question of what some of us have called the alleged action or inaction. Others have talked about as the period of liability. Others have talked about the period of the remedy. And at least in GL's view, once there is a timely filing, there is this sort of elastic notion that seems to be targeted to the remedy being relatively open-ended, depending upon when it, here comes that language, when the compensatory education claim accrued. And by the way, if you go back to accrual and the Section 1983 cases having to do with accrual of things like money damages, or here by analogy compensatory ed, you get to, ironically, something the courts have not yet really addressed, and that is the date that the district, the defendant, knew or had reason to know. My point is, it gets fairly complicated. But what is the relevant period for the remedy extending back before the Kosh? What is the date of the alleged action, as the question talked about? And I don't have a good answer for it. And is that alleged action or inaction the denial of FAPE, or as one of the participants had commented, don't get lost with that, just look at the remedy. And if you get to the remedy, and if it's comp ed, and there's a third if, and if the qualitative approach applies, and all three of those are hurdles in themselves, because first of all, for comp ed, there must be at least a denial of FAPE, and some will argue a gross denial of FAPE. Second is there is comp ed because of the requisite denial. Are you using the qualitative approach? I gave you some authority that seemed to suggest that your jurisdiction has moved in that direction, but it is not clearly settled. But this adds an added nuance. If we go back for a moment to those of you like Aaron who like the 2+2 only because the language seems to say that, if in effect in KH, if the parent filed within 2 and she could go back 2 more to 2 years before in other words, she filed in 2010, we go back to 2008. Now we go back to 2006 for the comp ed. And if the parent has proved the requisite denial, when we then use the Reed qualitative approach to see how much it takes for the 4-year denial of FAPE, it may be less than 4 years, or it may be more than 4 years. Now, I'm suggesting that this is just an added nuance. The harder point for me is whether you look at it as the remedy or the denial of FAPE or the language of action or inaction. How far back do you go to at least get to what I got to by the 2? Then once I'm there, if I'm applying the qualitative approach, I can go more or less than that. Now, some of you say, you know, he's sort of repeating himself. We're sort of, yes, we are purposely taking the basic concepts and then seeing how they apply in terms of the duration. What's the period? Is it 2 years, 4 years, or more? And then what's the effect ultimately in terms of the equitable remedy here in terms of comp ed? I added a case that I just discovered in my obsessive way last night by a New York review officer that is in special ed connection, that is just, you know, a month and a half old. But if you look at that case, it seems to me what the review officer did, rightly or wrongly, but nevertheless to the extent that the review officer is a level above the hearing officer, it says to the hearing officer in this case, the parent filed on X date, we go back 2 years. That is the limit for the denial of FAPE and for the remedy. It seems to me, again, you'll look at the case for yourself, but it seems to me that the review officer adopted what many of you have adopted up until now, and the various courts have, a look-back period, which assumes the legal fiction that the Kosh date was 2 years ago, and thus has a finite way of limiting things, may be completely wrong, and yet in terms of things like Ellen's point about numbers of hearing sessions and feasibility of the remedy, maybe at least there's some authority for that. But I add this in just because it shows the diversity of opinion and how the review officer may come into this equation. Moving on, there are a couple of other issues for you to keep in mind as you apply these concepts. One is this notion that I've mentioned more than one time because it can be a distracting, I'm thinking now of a swamp again, and yet is relevant and may be a solution as you look at a case like KH. I can just warn you that this notion of when did the claim accrue or when did the remedy accrue may or may not be relevant, but remember that if you look at the statutory language and the idea, there is a mention of Kosh, no mention of accrual. Second, if in fact we, through look back or through 2+2 or through stipulation or through your own sage way of concluding. You've ended up with a period of time, whatever it is. Let's just pick a period, 4 years or 2 years. Is the evidence limited to that? And there is ample authority, it seems to me, that I cited for you in the footnotes, yes, from other jurisdictions, but no split, that seems to suggest that once you define the period for at least the denial of FAPE, that demarcates the period of evidence, but it is not strict. There could be at least 2 reasons to stretch that date with regard to evidence, but to do it in a prudent way so that you manage the hearing efficiently. 1, if it's essential background information for me to understand this case. And 2, if we get to the notion again of the remedy, and if the remedy through the qualitative approach necessitates information going back further, then on either a bifurcated approach, and by the way, we could end up in effect with a trifurcated approach. In a very complicated case, you could have 3 phases. You could have an interim decision based upon the evidence, arguments, and your conclusions as to statute of limitations. You could have a second phase to determine whether, in fact, there was a denial of FAPE, whether the parent, whether there was this inaction. And then a third period, which could further extend the evidence to calculate the remedy. But often we don't get into that. It's one hearing. But all I'm saying is you've got discretion. Please do not abuse the discretion by being either absolute and saying, I'm putting on these blinders, I will not hear another piece of evidence behind 2 years. Seems to me that just engenders hostility and potential reversal unless you have absolutely good reasons for that kind of absoluteness. Or to me, what is equally or bad or worse than that, which is anything you want, let's go back to prenatal period, much less to the original date of creation. Again, going back to Ellen's point about, 14 sessions, etc. Let's move on. And finally, as we have pointed out various times, and as you have pointed out various times, New York varies quite a bit in its practice with regard to pre-hearing. And those of you who have found it feasible and favorable to adopt the kind of pre-hearing procedures that we have recommended will find that this becomes a wonderful place to try to accelerate and expedite your case by seeing, is it an issue? Are there stipulations? What are my expectations in terms of evidence so that we can all move along efficiently for the sake of the child, the school district, other children, and resources? If you don't do a pre-hearing, then please, very early on at that very first session, find out, is this an issue and what you need to move on about it, including encouraging stipulations. Now, I have some practice pointers, but I'm going to save them to the last 10 minutes because you can read them for yourself, and because my advice may not be as cogent or useful. I think a better way of us using our time, because it helps us make it more concrete, would be to go back to the KH case skeletal facts and at least tentatively share the varying interpretations and applications as to how far back you would go in this case. I'm bringing us back then through one document, which I'll now expand in size, but I admit that this is skeletal, and we're going to have, it's just sort of bare bones, but it's what I extracted out of the KH case, at least in terms of marker points along the timeline. Again, reviewing, let's go backwards on this one. The parent filed in June of 2010. And for those of you who are, scientifically precise, you may want a day. I don't know what the day is, but there was a day of filing. but if we just round it off for the purposes of simplicity, the parent filed in June 2010, and or the student filed it, and the student is not 21, so we've got a filing point that's relatively definitive. And a month or two before, we had a private evaluation that painted a pretty dismal picture of this kid's current condition, achievement, etc., and by implication makes one wonder about the effectiveness of the program that this child has experienced since kindergarten. Going back 2 years earlier, in 2008, 2009, and 2009 to 10, in those 2 years, when the child was discharged early in the school year of 2008, 2009, or at the end of the previous year, essentially we have a flagrant denial of FAPE for 2 years. And although the district is arguing that the parent is too late, by alternatively it seems to be almost acquiescing that maybe they could settle this case or at least limit the case to a 2-year remedy. But going back in time, then we find attendance problems, changes in placement, re-evaluations, improvement in behavior, not very much progress academically, hospitalizations, changes in custody, but it all dates back as early as, I mean, if you really went all the way back, New York City apparently first had responsibility for this child the year before kindergarten in pre-K, when there was first an evaluation in preschool services, but without that, at least 1994. So we have a 16-year period. You are the hearing officer. The parties have not made it easy for you. The district has timely registered an affirmative defense saying untimely, we think the case should be dismissed. Alternatively, if in your wisdom that it's not late, then we should limit the scope of evidence and liability to 208. The parent has argued various exceptions. And by the way, the one fact, in case you have this question, 1 or 2 times in the history of this, the parent did not get procedural safeguards. Yet in KH and otherwise, John, if you look at it, it seems to be harmless error, because although they may not have gotten it 1 or 2 times, they received the procedural safeguards repeatedly during this period from the very outset. So I don't think that's going to be the key to the case, but nevertheless, the parent may well argue withholding of information, misrepresentation, although we don't actually see much solid evidence of that, or continuing violations, etc., and or this notion of at least going back 2 years. At this point, I'm going to toss this hot potato first, as the rest of you think about it, to Aaron and to Ellen, with the understanding that they very well might be frustrated, angry with me, angry with Congress, wondering about legislative intent, but at least to give us initial, and they have not had time to do a bunch of homework on this, they can give us a representative view of what these things might be and where they might come out or how they might handle it. I think before, Aaron, that you gave Ellen a chance, so not to be sexist or otherwise, I'm going to turn it to you first, Aaron. What's your initial reaction to these arguments that the parties have made, and we are now at the beginning of the first session or a pre-hearing session?
And before Aaron speaks, I just want to point out for those out there that code number 4 is on your screen. I'll leave code number 4 on the screen while Aaron and Ellen are making their comments.
Thank you.
Okay, thank you, Perry. Okay, this is my off-the-cuff reaction to your question. It's not clear from the presentation of facts here. It probably is clear from the actual case what the parents factual allegations of denial of faith are. But I'm willing to take and I assume that this corresponds to the actual facts of the case. The parent counter argues that the triggering date for the SOL was May 2010. So I assume from that the parent is arguing these are things that we're learning for the first time that my child had all these problems, and this is the date that I knew or should have known of all these things which you didn't remedy. So with the 2 plus 2, which I said I'd like, I would go back to May 2008 and take it from there, because I would, as far as the discharge from the program due to continued truancy and the parent's lack of response, it may be, I think you're correct that that's a blatant denial of faith, but it's not clear to me that the parent, at least from these facts, that the parent is making an argument about that, because a lot of parents just assume their kids have no interest in school, and for all we know, maybe this child, in addition to whatever the reason he may have had no interest in school, just didn't have an interest in school. But I would assume that the parent's grievance has to do with what came out of the private neuropsychological evaluation, and I would take it back 2 years before then.
Very good. That really helps us, because it gives us a finite and a relatively cogent and concise way of handling the matter. Now, we can get into other nuances for Aaron, like the fact that he's moving us back 2 years, but I hear him implicitly saying, first, he wants a better notion from this parent as to exactly what they argue the denial of faith is. He wants to look at the evidence, make legal conclusions, and if and when he gets to the equitable remedy of comp ed, he'll be looking at the responsibility of both parties and what it takes in a qualitative approach. But right now, at least, it's a 4-year period going back to May 2008 as the sort of window that will be the main focus. Okay, Ellen?
So I think I agree with Aaron in that 4-year window. I'm concerned by some of the facts, because some years it says the parent was involved, some it wasn't. Does it make a difference? Sometimes it was the grandmother, and then it became the student. Because if you're going to knew or should have known, who knew what? As I see it. And then as I read the facts, the district evidently was trying to do something. They changed placements several times. I don't know, it would come out in evidence whether this was trying to work with the child for the benefit or it truly was denial of faith. And then I am very concerned for those 2 years when there was no IEPs or evaluations.
What would be the at least tentative limitation as far as our main focus for both evidence and the denial and remedy in your case? Are you going to open it up and let's see what they say, or are you going to pick some finite point like Aaron did?
I think, and I don't have a decision yet on this, I think I would make it finite. I don't think I would go back to 94. I think, like I mentioned before, you get into an impossibility of how do you ever do comp ed for that?
Yeah. And one other point you did make that I think is quite relevant. We'll see many cases where the kid might get an IEP early on, and every IEP after that is just simply a variation on the same theme. It just takes the IEP and sort of updates it. You point out that when we look back there, at least from the district's point of view, they did the periodic evaluations and they responded each time by changing the placement of the child. So at least we don't have that sort of what some of you called a continuing violation, at least of the same sort, although it may be a continuing series of different kinds of violations. But again, whether you're Judge Judy or Judge Aberbach, you're saying I don't have a decision yet. Let me, during the commercial at least, think about this thing a little bit more, because it is relatively complicated. Now, Dave Steady, as far as folks out there, because I'm sure there's a diversity of opinion, if they will please, as they've been doing so far, register with you their comment, their sort of tentative decision, we will hear them. And if you don't have any yet, I'll go to the practice pointers and come back.
Right now, they're reserving opinion. If they come in, I will share them. But I do have one question, and that question is: Are we not bound? Are we not bound by the unreported but unofficially reported decision in KH? What difference does it make if the decision is unreported?
Boy, you know, this is beautiful. It's as if I planted people in the audience for transitions here, because that's where I was going to go next. Now, as far as whether it's binding on you, I'll leave that to you. The arguments are, yes, it's binding because it's a federal district court in your jurisdiction. The counter argument is, yeah, but it's an unpublished case, and if you really look at it, even for published cases, the federal district court cases are not binding on other district courts. Counter argument again, well, they may not be binding on other district courts, but they're binding on me, the hearing officer. Now, I think there's an easier way out, which is, let's assume for the sake of argument that KH is binding. When you look at the decision, you're going to find that it is relatively limited and fairly easy to distinguish. I'm just going to give you some highlights from this case. It's found right there in IDLR and Special Ed Connection. You don't need Data Study to email it to you. You will see as I scan down the initial pages, I've highlighted some of the facts just to show you where I received them from. And by the way, I left out because we're taking it going forward to hearing. But in this case, the hearing officer used the 2-year look-back period. And the review officer largely upheld the hearing officer's notion. Now, in terms of comp ed, we're going to go up, but as far as the statute of limitations, the parent appeals it to the federal district court. The federal district, and by the way, the other complication, which you don't have to worry about at least, is Section 504, alternative claims, because there's a separate statute of limitations there, which is not explicitly in the statute. But getting to the heart of the matter, my first point is this. This case has got, you just have a little skeletal thing, 28 documents totaling over 1,000 pages from this long hearing. Records dating back to the 1990s, but reminding us of Ellen's point about practicality and the general notion of staleness. The judge admits there are, despite the 1,000 pages, going all the way back, significant gaps and inconsistencies. Second point about this particular case is that when we get to the parties, I want to, while I'm looking for it, I can tell you what I'm looking for, which is the procedural posture of this case is that the attorney for the city and the attorney for the parent have said to the judge, give us a basic ruling on statute of limitations without getting into all of the details and the substance as to whether or not there's been a denial and what the remedy is as the basis for settlement. So the context of this ruling is very sort of preliminary to sketch out the outer boundaries for purposes of settlement. Then moving into what the court actually does, I'm scanning down. Here's the notion I was looking for. At a conference before this court, the parties indicated would facilitate settlement discussions if the court addressed statute of limitations at the outset and determined how many years and which school years were dismissed as time barred. And as I look at this and think of this judge and think of some of ourselves, judge doesn't get an A+, as many of us don't get, like professors, in that we sometimes don't, and politicians don't directly and definitively answer the question. But let's see how this judge answers the question. The judge first points out this notion that the DOE had the burden of proving this. So this notion of burden of proof. But then the judge goes into that muddy matter of talking about accrual in the context of kashk. Then, moving on with the judge's opinion, faulting the hearing officer and the review officer for getting into the fine-grained analysis, which is what I've been attempting to do, all these fine sandy grains, and saying that we don't have sufficient fact-finding for us to determine all of this. Thus, the judge, pointing the finger at you folks, says, at this stage, I find it unnecessary to address the timeliness of each of the plaintiff's specific IDA claims, reminding us again of both what Aaron and Ellen said. What were the specific claims? It seems rather amorphous. This judge sort of ducks. I conclude that both of you, hearing officer and review officer, a pox on both of your houses, erred in summarily dismissing everything. Now, what they did, unlike Aaron and tentatively Ellen, wasn't a 4-year period. They did 2 years. Look back of 2. Judge says, nope, that's wrong. I conclude that the claim did not, notice that language, accrue, but using the language I think it was that Ellen said, or that Aaron might have, but both of you got into this notion that it's when the parent got that report in 210, a few months or a matter of a couple of months before filing, that's when the parent, that's the Kosh date. That's when the parent knew or first knew that this child had all these DSM-type specific learning disabilities and thus did not have reason to know that the denial of FAPE was that the IEP was not geared to address those learning disabilities. If you remember, early on, the kid was identified, but subsequently it switched to ED and ID, where the focus was not targeted to the dyscalculia and the dysgraphia and the dyslexia of this child. Now, so you see the Kosh date then is essentially May of 210. Thus, if you all agree that that's the date, then the parent timely filed. Then the issue becomes, okay, judge, this parent is timely filed. How far back do we go for our settlement? Here's where it gets to me rubber bandy-ish. Since the claim did not accrue to 210, it falls within the statute of limitation, precludes dismissal of the claims from 1994-95 onward. And I don't even know how they got rid of preschool. But it seems to me it's pretty, if not infinite, it goes way back. He then repeats, it's the 210 report that's the first time the parent was on notice of the failure to identify and address the learning disabilities. Now it seems like it, oh boy. But then, so you say, okay, do we go all the way? You're giving us all those years? However, I simply cannot say the KH's mother, as some of you pointed out, or grandmother should have known to file when they learned how little his progress was making in school. This is sort of the reasons of earlier, because they had no reason to know how much progress he was capable of making. Here the judge, it seems to me, is sort of reinforcing the notion that there was not an earlier Kosh date. At the same time, he seems to be making irrelevant the exceptions of misrepresentation, because once you're in the ball game, you're in the ball game. So how far back does the ball go? At this point, he's then saying they didn't have the necessary information earlier. Plaintiff had asserted a claim spanning all of those years that is timely because it didn't accrue to 210. In light of this finding, it is unnecessary to address the arguments or the exceptions. Okay, so he ducks all of the exceptions, doesn't give us any authority on that. And I don't think I highlighted it here, but somewhere in here, you'll see it for yourself. He ends up saying, but I'm not telling you which years there was a denial of faith, and I think that some of those years will not count, but since you've given me such a sketchy record, settle it, and if you don't settle it, presumably it will be remanded. So my answer is KH may be binding, but I'm not really sure what KH has said. KH does not seem to agree 2 plus 2. KH doesn't mention GL or the GL logic, but nevertheless comes out somewhat like GL, rubber bandedly, but is excusing the lack of more definitiveness because it's a settlement case and admitting that some of the years, maybe a lot of them before 94, will not count. Dave Steady, I've got 4 minutes. I can go to practice pointers or comments depending upon what you may or may not have at this point.
I do have a question, and I have to put up the last code, Perry. But the question or the comment is as follows. Isn't the remedy easier than it looks? If there was a denial every year since 1994, the remedy would still be to identify the services needed now to remedy the student's situation now, not in 94, 95, etc.
I wish I could answer. The answer was yes, but I don't read Reed as saying that. Reed seems to be targeted to the denial of faith. If, in fact, this kid was denied 16 years of faith, then it seems to me, you have to read more carefully because it has a little logarithm, but what it boils down to is what would it take to make up for whatever the 16 years of denial of faith accounted for, unlike what other factors accounted for. So I don't think the remedy in this case, if you did agree that there was a 16-year denial of faith, is going to be an easy calculation, or, going back to Ellen's original point, an easy and practicable allocation of resources. Let me go to my practice pointers, and you'll give me back the screen as soon as you can, but I will at least, you have them there in front of you.
First, the screen is still in front of you. Still have the screen, but I'm going to have to take it from you in about 2 minutes.
Okay. Well, you do it when you think it is relevant. My first point is, please be ready. Don't get caught unawares. If the parties don't bring this thing up, then don't. It seems to me, do what you think is best, but that's not the problem. But if they start arguing Koshk and exceptions and remedy, etc., then please, early on, make it clear to them as part of your efficient management of the hearing, what are you expecting from them, and how are you going to make a determination? Are you going to give them an interim decision early on? Are you going to bifurcate? Are you going to wait for it all at the end? Be ready to come up with some kind of initial guidance that puts you in control of this situation, because it can easily get out of hand. You could spend more time on the statute of limitations than you can spend on the fate. Second, if the triggering date is at issue, the Koshk, make sure that you warn the parties, especially the district. You've got the burden of proof to show when this parent knew or had reason to know. And of course, the district is going to say, well, how do we know? Well, you give me whatever evidence that I can infer from that. And parent, you better be ready to rebut it. And I'm only going to use burden of persuasion, as we've said before, if it's a tie. Otherwise, it's just which is more preponderant. If exceptions are at issue, and I wouldn't put them at issue, but if they are, they've got to raise them early. Are you talking about continuing violations? Are you talking about misrepresentation? If you do, here are some cases. Give me the arguments, the authority, and the evidence. If not, they're waived. And the hardest part of all, I believe, at the end of this session is if the parent has timely filed, which is an issue in itself, but if they have, start thinking about what one of the participants here has labeled liability and remedy, what some have talked about in terms of the action or inaction the denial of FAPE, and when did it all start, and how far back are we going to go? Because it has implications for the arguments, the evidence, and the ultimate decision you make with regard to the remedy. I add in another footnote of a brand new case that I just saw out of Texas. In the Texas case, the hearing officer did not give the parents what the parent regarded as a fair and full opportunity to make arguments and evidence as to the applicable statute of limitations, and the court, as it often does, gives you the discretion to manage the hearing within the context of the 45-day period and efficient administrative adjudication. And if you take control, unless you abuse your discretion, you have more latitude and more authority than some of you think, and for the benefit of everyone, you can make this a much less complicated matter than I have. And finally, please make extra efforts here that if this is an issue, that your facts, unlike the KH facts, and your legal conclusions, like Aaron's notion of 2 plus 2, are cogent and cite the kind of authority that I've sent to you that you can just cut and paste and argue the way you see is persuasive. Because the advantage is, one, the parties are unlikely to appeal, so we can all get on with the business of helping KH and the other kids in New York City. Or two, if they do appeal, that this case law becomes crystallized in such a way that it makes sense from the point of view of a hearing officer who knows reality and knows the situation and context much better than some Lehigh professor or the Second Circuit or the Federal District Court, and thus becomes good, sensible law for future training and for the benefit of the parties and the sake of what special ed law is. With that, Dave Study,
the code number 5 has been on the screen for some time. We're going to end it there. I want to thank Aaron and Ellen for your participation. I want to thank everybody else for being here. We'll see each other in May again for the third and final webinar of the current year. Have a good night, everyone.
Thank you, everyone, especially Aaron and Ellen.